Good afternoon, everyone, and welcome to this afternoon's meeting. Before we begin, we'd like to ask everyone to please bow for a moment of silent reflection. And thank you. Mr. Midges, if I don't knock this microphone over.
Good afternoon, Mr. Chairman, Commissioners. Our next agenda meeting is scheduled for Wednesday, June 26, 2019 at 2 o'clock.
Okay. We're good. June 26 at 2 p.m., not 2 a.m.
On our supplemental agenda, we have petitions to intervene in dockets number 2019-176E, 2019-184E, 2019-185E, and 2019-186E.
Mr. Chairman,
Commissioner Belzer.
these four dockets were established by the Commission in the last couple of Commission meetings as a result of recent legislation from the General Assembly. These four items are all petitions to intervene by Johnson Development Associates, Inc., and I move that we grant the petitions to intervene filed on behalf of Johnson Development Associates, Inc. in these four dockets.
Thank you. You've heard Commissioner Belzer's motion. Are there questions or comments? If not, all in favor, please say aye. Aye. All opposed, no. Motion carries. Thank you.
Mr. Chairman, also on our supplemental agenda, item numbers 5 through 8 are petitions to intervene by the South Carolina Solar Business Alliance. It's item 5, docket 2019-176E. Item 6, 2019-184E. Item 7, 2019-185E. And item 8, 2019-186E.
Mr. Chairman.
Mr. Belzer.
Similar to the previous four dockets, these are the same four dockets, but these matters are petitions to intervene filed by the South Carolina Solar Business Alliance. And I move that we grant the petitions to intervene filed in these four dockets on behalf of the South Carolina Solar Business Alliance, Incorporated.
Thank you. You've heard Commissioner Belzer's motion. Questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
On our utilities agenda, item number 1, docket 2008-140A. We have a request for an extension of time.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, I would move that we grant the request for an extension of time for Lakewood Utilities, LLC to file the company's annual report. So move, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item number 2, docket number 2017-292WS. Blue Granite Water Company is seeking rehearing or reconsideration of Commission Order number 2018-802.
Mr. Chairman.
Commissioner Howard.
Chairman, Blue Granite Water Company, formerly known as Carolina Water Services Incorporated, which I will call CWS for the purpose of this motion, has filed a petition for rehearing and reconsideration of Commission Orders number 2018-802. CWS argues several points, including the assertion that this commission earlier granted rehearing in order to determine the reasonable of the utility's attorney fees in the case, but not the separate question of whether the expenses were reasonable and necessary to the provision by CWS of utility services to its customers. Therefore, it argues that a rehearing should be ordered with appropriate notices of the issues to be considered by the Commission. Further, CWS has filed a supplemental memorandum of support, a petition for a rehearing and reconsideration. With it is submitted 2 exhibits which deal directly with the River Keepers litigation that is the subject of the CWS petition. The company claims the evidence demonstrated significant benefits for the litigation to the ratepayers. CWS inserted that it may provide such additional evidence pursuant to 58-5-330, which allows Commission upon the application of rehearing to consider all the facts, including those arising since the making of the order. Since CWS has submitted new evidence pursuant to the statute, and since it's claimed that the Commissioner needs to provide appropriate notice of issues to be considered by the Commission on rehearing, I move that we grant rehearing, that it should be considered, shall be a three grounds as enumerated in the company's petition. However, ground number 3 shall be modified to include facts and issues raised by the supplemental memorandum and exhibits in support of CWS's petition for rehearing and reconsideration. Further, I move that the order which results from this motion should include a date by which the parties shall file briefs with the Commission regarding each party's position on number 1, whether rehearing should be carried out through the submission of briefs and oral arguments, relying on the record as established in the September 2018 hearing and CWS's supplemental memorandum, or number 2, whether additional witness testimony and exhibits would be needed to rehear the Riverkeeper's litigation issues raised by the company. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Howard's motion. Are there questions or comments?
Mr. Chairman,
Mr. Belzer.
I have recused myself from this docket due to a conflict with my prior employment on this case.
Thank you, Commissioner Belzer. You are recused. Okay, any other questions or comments? Not all in favor, please say aye. Aye. All opposed, no. The motion carries. Thank you.
Item number 3, docket number 2019-164E. It's a motion to dismiss the complaint of Charles Hawkins.
Mr. Chairman,
Commissioner Belzer.
Mr. Hawkins has alleged no violation of a commission rule or statute in his complaint, and he has not responded to Duke Energy Carolina's motion to dismiss, which was filed on June the 4th of this year. The verified testimony from Pam Howes, a consumer affairs analyst with Duke, indicates that power has been restored to his residence following a payment and an agreement for a new payment plan. Therefore, I move that we dismiss this complaint of Mr. Hawkins.
Thank you. You've heard Commissioner Belzer's motion. Are there questions or comments? If not all in favor, please say aye. Aye. All opposed, no. The motion carries. Thank you.
Item number 4, docket number 2019-1E. Duke Energy Progress LLC's annual review of base rates for fuel costs.
Mr. Chairman.
Commissioner Williams.
Mr. Chairman, I move that we adopt generally the joint proposed order filed on behalf of the Office of Regulatory Staff. The net effect of my motion is a decrease of $1.95 per month based on a 1,000 kilowatt hour monthly usage for a residential customer. More specifically, I move that we adopt the amounts stipulated between the parties, consisting of a totally combined fuel factor of 2.865 cents per kilowatt hour for residential, 2.657 cents per kilowatt hour for non-demand general service, 2.075 cents per kilowatt hour, for demand general service, and 2.075 cents per kilowatt hour for lighting. Additionally, I move that we adopt the NEM distributed energy resource values and the DERP charges stipulated between the parties. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Williams' motion. Are there questions or comments?
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, let the record show that I'm not voting. I was not present for the hearing, was on annual leave for my daughter's graduation. I'm not voting.
Okay, well, so noted. Any other questions or comments? Not all in favor, please say aye.
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 All opposed, no. Motion carries. Thank you.
Item number 5, docket number 2018-319E. We have petitions for rehearing or reconsideration of Commission Order number 2019-323.
Mr. Chairman,
Commissioner Irvin.
3 parties have contested certain portions of Order Number 2019-323 and have sought reconsideration and or rehearing. Those 3 parties seeking relief are Duke Energy Carolinas, the Office of Regulatory Staff, and the South Carolina Interusers Committee. This motion summarizes my proposed action to be taken by the Commission in connection with the petitions for rehearing and reconsideration, with the understanding that the Commission will file a full formal written order explaining the rulings in more detail. To the extent that I proposed upholding the Commission's original rulings, I move that we find there is substantial evidence in the entire record to support our findings of fact and conclusions of law. Let's take up the three parties' motions for reconsideration. The South Carolina Energy Users Committee petition presented three requests for reconsideration. I move that we deny South Carolina Energy Users Committee request that the Commission disallow entirely the pre-construction costs incurred in connection with the Lee nuclear plant. If the General Assembly had intended to bar all nuclear pre-construction costs in Act 258, it would have said so explicitly. However, it did not. I further move that we deny South Carolina Energy Users Committee's request that we disallow entirely the cleanup costs incurred by the company in connection with the excavation of coal ash basins at W.S. Lee Steam Plant Station. These cleanup costs were incurred pursuant to an agreement between South Carolina DHEC and the company. Finally, I move that we deny the Energy Committee's request that we require the company to implement market-based real-time pricing. Real-time pricing tariff is, as the company explained, a voluntary tariff based on the company's system production cost and are not intended to be a proxy for wholesale market-based pricing. I further move that we adopt the following modifications to Order Number 2019-323 as proposed by the Office of Regulatory Staff. 1, clarify DEC's allowable rate base and net income for return. After adjustments made on reconsideration, which I will address later in my motion, the allowable rate base is $5,445,665,000, and the net income for return is $390,133,000. 2, we should clarify that the company, for purposes of this rate case, is to use the cost of service study presented by the company to allocate all revenues, expenses, and rate-based items, and to design rates for all customer classes, unless otherwise specified by the Commission. 3, we should clarify that the Commission intended for our order a 75% disallowance of the $1,094,000 portion of Duke Energy CO Lynn Good's executive compensation allocated to South Carolina ratepayers. The resulting net adjustment to executive compensation and adjustment number 29 would be $1,222,000 rather than $1,085,000. 4, we should modify our ruling as to the calculation of working capital, adjustment number 333, which should be adjusted from $83,971,000 to $82,230,000. 5, with regard to treatment of deferral accounting treatment for certain costs, I move the Commission adopt the following. A, Customer Connect operation and maintenance deferral. The Commission should permit continued deferral of costs incurred in connection with the ongoing deployment of the Customer Connect program, consistent with Order Number 2018-552 and docket number 2018-207-E. B, AMI deferral. The Commission should permit deferral of costs incurred in connection with the implementation of advanced metering infrastructure. C, coal ash deferral and amortization. The commission should permit continued deferral of costs incurred in connection with complying with environmental remediation requirements consistent with order number 2016-490 and docket number 216-196-E. In addition, we should clarify in our final order that the amortization period for the previously deferred environmental costs is 5 years, as proposed by the company and unopposed by ORS. D, grid modernization deferral. The Commission's hearing officer directive order number 2019-26H approved the stipulation governing the deferral of the proposed grid modification plan. To clarify, as requested by ORS, the Commission should adopt and incorporate by reference the terms of the stipulation in our final written order. E, credit card fee deferral. The Commission should grant the company's request that it be permitted to defer costs incurred in connection with the implementation of its proposed transaction fee-free credit card payment program. 6, I move that we reject the ORS argument to the effect that the notice the company served concerning rate increase proposals in some way violated due process or was otherwise deficient. The petition filed by Duke Energy Carolinas seeks reconsideration and rehearing as to many rulings contained in our order number 2019-323. I move that we take the following actions as to the DEC petition. 1, the Commission should decline to rehear or reconsider its rulings in connection with adjustments numbers 7, 13, 18, 19, 30, 35, and 36. 2, the Commission should decline to rehear or reconsider its rulings in connection with coal ash remediation and disposal costs. 3, the Commission should decline to rehear or reconsider its ruling with respect to the approved return on equity. 4, the Commission should decline to rehear or reconsider its ruling that DEC be entitled to recover return on deferred costs with the exception of the coal ash cost, and only be allowed to return a return on its capital-related deferred cost. 5, any and all requests for rehearing or reconsideration not specifically addressed in my motion should be denied. I so move, Mr. Chairman.
Thank you. You've heard Commissioner Irvin's motion. Are there questions or comments?
Mr. Chairman,
Mr. Williams.
I just want to briefly comment on the ORS argument regarding the notice the company gave regarding the rate increase proposal violated due process or otherwise was deficient. I think it's a stretch to say that the notice violated due process. I think we saw from the public hearings that ratepayers had the opportunity to be heard. They knew that the company was seeking a rate increase, and they had the opportunity to be heard and respond regarding that matter. What I will say, I tend to agree that, even though I disagree that the notice violated due process, I do agree that it may not be good sound public policy to notice certain rates and charges and then allow increase above what is noticed. I'm going to quote from ORS's petition for reconsideration and clarification filed on May 31st, 2019 by Attorney Jeffrey Nelson. And I quote, "For future, utilities should be aware that in filing a rate case application and noticing rate charges, the utility cannot simply make dramatic changes and ultimately result in a revision of rates higher than that noticed and requested. Any potential for alternative requests should be clearly spelled out." And I really want to focus on that last sentence. When we consider the average ratepayer that we saw at the night hearings, I'm not sure how many of them actually read every word of the notice that was sent out. Maybe they did, maybe they didn't. But I think it would be fair for all involved if the application, the notice for a rate increase is in as plain a language as possible and all the important details are up front, to use an Army acronym, bottom line up front. I know that things changed with this case due to the fact that the company adopted ORS's lower BFC. Originally, they were seeking $28, I believe, and that went down to about $11.96 and so forth from there. And that changed the variable rate, and I'm not sure how many customers really understood that. And so I don't agree that the due process rights were violated, but I think it is good public policy to make sure that notices and applications are clear to the average ratepayer. So when they do come to a public hearing, maybe as opposed to just talking about the increased BFC, for example, they would also talk about, well, maybe my volumetric rate will go up if they don't get the BFC. So those are my comments, Mr. Chairman, and I appreciate your motion, Commissioner Urban.
Thank you, Commissioner Williams. Any other questions, comments? Commissioner Belzer.
Thank you, Mr. Chairman. This is sort of a nitpicky thing, and I apologize, Commissioner Urban, but I thought when you were making your motion with regard to your item number 4, I believe you indicated that was adjustment number 333, and from my notes, I think it's adjustment 33. Would you clarify?
Yes, if I said 333, I misspoke. You're correct that it is adjustment number 33.
It was a long case, but I hope we didn't have 300 adjustments.
Stand corrected. Thanks for catching that.
And with regard to the notice issue, I certainly appreciate Commissioner Williams' concerns. I think anything that we can do and that the parties can do when notice is being given to make it clear to the ratepayers and consumers, that's always a good thing. I will note that I raised an issue. I asked a question of one of the witnesses about the notice. And at the time, I was thinking, and after I asked, I should have looked at the notice before I asked the question, but when I asked the question, I was under the impression that the energy component was listed in the notice of the hearing, notice of filing and notice of hearing, and it was not. But the notice did state that Duke was seeking additional revenues of however many millions of dollars and a percentage. And then in the next paragraph, it set forth the specific base facility charges that it was seeking for various classes of customers. It did not, however, list in the notice a specific energy component related to the various rate schedules. I know that we have to be careful with the notice because if it had to list, if it had to be so comprehensive as to list all of these in these large electric rate cases, the notice would go on for pages and pages and nobody would read it. I'm quite sure, or I feel like that would be the case. When I did realize that the energy charge was not specifically related, was not specifically listed in the notice, that alleviated my concern, a lot of my concerns on the adequacy of the notice. And I feel like that it was an adequate notice just going forward. Thank you.
Thank you, Commissioner Belzer. Any other questions or comments? Okay, not. All in favor of the motion, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
Item number 6, docket number 2018-318E. We have petitions for rehearing or reconsideration of Commission Order number 2019-341.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, we have received 3 timely petitions for rehearing or reconsideration, one each from Duke Energy Progress, the Office of Regulatory Staff, and the South Carolina Energy Users Committee. I will briefly address my proposed action with the understanding that the Commission will issue a full order explaining the rulings in more detail. To the extent that I propose upholding the Commission's original rulings, I move that we find there is substantial evidence in the entire record to support our findings of fact and conclusions of law. I would like to begin with the energy users petition. It raises 2 points for reconsideration or rehearing. The treatment of recovery for coal ash remediation costs at H.B. Robinson plant and the real-time pricing rates available on the relevant tariff. Mr. Chairman, I move that we decline to change our ruling on either of those 2 points. The cleanup costs incurred at H.B. Robinson are pursuant to an agreement between South Carolina DHEC and the company. The real-time pricing tariff is, as the company explains, a voluntary tariff based on the company's system production cost and are not intended to be a proxy for the wholesale market-based pricing. Mr. Chairman, I move that we take the following action regarding the Office of Regulatory Staff's petition. Number 1, clarify Duke Energy Progress allowable rate base and net income for return. After adjustments made on reconsideration, which I will address later in the motion, the allowable rate base is $1,477,356,000, and the net income for return is $103,271,000. Number 2, clarify that the company, for purposes of this rate case, is to use the cost of study presented by the company to allocate all revenues, expenses, and rate base items and to design rates for all customer classes unless otherwise specified by the Commission. Number 3, clarify that the Commission intended to order a 75 disallowance of the $351,000 of Lynn Goods executive compensation allocated to South Carolina ratepayers, a net allowance of $88,000, rounded with all attendant adjustments as recommended by ORS in its petition. Number 4, disallow $178,000 of non-allowable expenses remaining in dispute. I would reiterate that we will hold a proceeding to further clarify what treatment is appropriate for these types of expenses. Number 5, I move that we correct a clerical error, DEP accounting order number 2018-553, not order number 2018-552, should be declared null and void. Number 6, clarify that the AMI deferral continuation sought by the company is granted, subject to the deferral treatment outlined in Section 4.K of the order. Number 7, correct Section 4.L of the order to include adjustment number 18. The remainder of the coal ash deferral not addressed in Section 4.B of the order, including the non-asset retirement obligation amount, should be afforded the same treatment as ordered in Section number 4.K of the order. Number 8, explicitly approve the grid modernization deferral as stipulated between ORS and the company. Number 9, I move that we decline to rehear or reconsider the sufficiency of notice issue. I move that we find the notice was issued to be sufficient under due process considerations. Mr. Chairman, I move that we take the following action regarding Duke Energy Progress's petition. Number 1, decline to rehear or reconsider the Commission's decision on coal ash costs. Number 2, decline to rehear or reconsider deferral treatments specified in the Duke Energy Progress petition to include adjustments 17, 18, 19, 30, and 35. Number 3, decline to rehear or reconsider the 9.5% approved return on equity. Number 4, decline to rehear or reconsider coal ash litigation expenses adjustment number 36. Mr. Chairman, with a little bit of difference here, number 5, upon further reflection, I move that we do reconsider the treatment of certainty litigation costs. The company's decision to defend itself and to enter into the settlement was a strategic, reasonable, and prudent decision. And, Mr. Chairman, I would note a decision that directly benefited ratepayers, had a net benefit to ratepayers of $50 million. Therefore, the certainty litigation cost adjustment of $830,000 should be recoverable. Mr. Chairman, I so move.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments?
Mr. Chairman,
Commissioner Williams.
regarding Commissioner Whitfield's comments on the due process argument, same arguments I had in item 5, I have for item 6. I did want to, in addition to that, I did want to address the issue of certainty. Mr. Chairman, fellow commissioners, Commissioner Whitfield, I have some concerns when it comes to the company entering into a contract with certainty to sell gypsum, a byproduct of making electricity. We learned that the gypsum is produced and something has to be done with it, put in a landfill, or you could sell it. Well, in this case, they decided to sell it, got a 20-year deal with the option for 2 extensions of 10 years to provide 50,000 tons of net dry gypsum. And then things changed, and the company could no longer provide that amount, and litigation ensued, and we have a settlement of $90 million that the company is asking the ratepayer to bear because they benefited from the sale and the avoided costs. But just as simply as the company entered into that contract, there are many other options that we don't know of what they could have done, but they could have done different things. They could have given it away, and it wouldn't have produced this litigation. And what I feel as if I heard from ORS is that because the company entered into this contract, they have to own the consequences of the contract. Yes, if the contract would have gone forward as written, the customers, the ratepayers, would have definitely benefited. There's no doubt about that. But that didn't happen. And I don't know how prudent it is to enter into a 20-year contract to provide coal ash byproduct, knowing that the regulatory environment could change, knowing that so many unknowns exist over a 20-year period. I just question whether or not it's a good idea to put that on the ratepayers' back. Could you help me through some of those questions?
Yes, Commissioner Williams. I guess first I would start by saying, just to kind of clarify, the gypsum is the product, the end-use product, the certainty to sell. And of course, the raw material or used for that product is the coal ash byproduct. So they're still taking the product to make the end-use product, the gypsum, which is sold, and they would have had to produce more than this amount for many, many years to supply the certainty with this raw material. And I think it's pretty clear that with the decline in coal generation, that the company couldn't meet that obligation. I think I remember from testimony during the hearing that the company even bought product to help supply that for quite a length of time. And then at some point, the company, realizing that it wasn't going to continue to produce the level needed to meet the certainteed obligation, ended up deciding it was time to litigate. And the net benefit, is my understanding after the litigation, is a net benefit of $50 million to the ratepayers after the everything's all settled. So I think the company, while the interveners made and others, ORS and others made a strong argument during the hearing, to break a contract was imprudent, but at some point, it may have been more imprudent to continue having to buy gypsum and raw material to make the gypsum, rather to supply certainty. So at some point, for lack of a better term, they had to lawyer up and get out of this contract, and the net benefit to the ratepayers is $50 million, and therefore, on reconsideration, I'm moving that the $830,000 in litigation costs be recoverable. I hope that helps you.
It does. It helps me a little bit out. Let me ask you this: do you give any consideration to entering the original contract in the first place? I mean, it seems to me that the contract terms were agreed to by the company. We had no involvement. The ratepayer had no involvement. They contracted to provide 50,000 tons per month. They could have, in the same vein, they also could have contracted to provide as much gypsum as that plant or much coal ash as produced, without adding a level of liability to create the situation for special damages or even breach. I guess that's what causes a little bit of a concern for me.
Well, I would say, as was brought out during these cases, both of these cases, that our ratepayers benefited for 50-plus years from coal generation, and I think back that many years ago when the contract was entered into, that it was widely presumed that our level of reliance on coal-fired generation would continue long enough to meet this contractual obligation with certainty.
Let me let Commissioner Belzer weigh in for a second.
Thank you, Mr. Chairman. I'm in agreement with this portion of Commissioner Whitfield's motion. As I recall from the testimony, I believe it was covered by Duke witness Coppola, and ORS witness Morgan, and ORS witness Ham. And I think ORS was taking the position that more information needed to be provided, that there was a breach with certainty. One of the parties, I believe it was Mr. Morgan, had as an exhibit to his, I think it was his rebuttal testimony. Could have been his direct, I apologize, but he included the order of the business court from North Carolina. And in that order, it kind of went through the progression. I think there was talk of a 2004 agreement, a 2008 agreement, and a 2012 agreement. And in the 2012 agreement, it appears from the order that Duke, and I think this is bolstered by witness Coppola's testimony, that Duke was beginning to realize that perhaps production from the coal plants was decreasing. And I actually am looking at the order, and they had, Duke had successfully had some language, or successfully amended the previous language from the 2008 agreement to include some language that said, or the aggregate, well, it's talking about that they would provide 50,000 net dry tons, and then this other language that was added to the 2012 agreement, or the aggregate actual gypsum filter cake net dry tons produced buy the Roxborough plant and the Mayo plant over the same period, whichever is less. And to me, what that is saying is that Duke was trying to amend the contract to allow them to provide less than the 50,000 tons. Now, the business court found they didn't buy that argument, and said that Duke was responsible for the 50,000 tons. At that point, Duke was faced with either having to purchase gypsum to fulfill the contract. They could have appealed, gone through a lot of litigation expense, and possibly lost on appeal and still ended up where they were, and they elected to settle. And I think that they did what they could do at that point and went with the liquidated damages. And as the testimony of witness Coppola indicated, there was ended up being a net benefit to the ratepayer. This contract had been entered in, or some form of the contract had been ongoing for many years. And until you get to the point where all things coming about, that as we know the industry, that coal-fired generation is decreasing, natural gas is increasing, just because of the cost of it, I can't find fault with Duke's business decision on this one. And I will agree with Commissioner Whitfield's motion on this issue. Now, that being said, I think this is a good time to put the parties on notice and everybody listening. We need some more information on some of these issues. And I think trying to get by with less is not going to get you anywhere. Give us the information to really make your case and persuade us, and let's go forward from here. But there are a lot of issues where I'd like to see some further information from the parties. And don't just hang your hat on saying it's presumed reasonable, and until somebody questions it, that's all we're giving you. Give us what you need to up front to show the reasonableness of that presumption of reasonableness, and don't skimp on the evidence. Let's just get it all in and go forward. That's just my position on that point. Thank you.
Thank you, Commissioner Belzer. Any other comments? Commissioner Williams.
Mr. Chairman, thank you. Commissioner Whitfield, Commissioner Belzer, thank you for your commentary. That's helped out some. And what I will add to that is that we all know this, but it is worth saying that this commission is the only thing standing between the ratepayer and an increase in rates. And the same language that Commissioner Belzer referenced that was added in the 2012 contract, in my opinion, should have been in the original contract. Now, I'm playing Monday morning quarterback and backseat driver, but from my position, when the ratepayer is going to be on the hook for your decision, there needs to be a certain level of hesitancy and conservatism used when deploying bright ideas. I don't want to beat the company over the head for being industrious and attempting to do something positive to benefit the ratepayer. But here again, we have a situation where what we thought would work out just didn't work out. But yeah, there's a benefit to the ratepayer. So I mean, I understand the net benefit. I get it. But at the same time, I agree with Commissioner Belzer. I need more information to make full, complete decisions, as opposed to just making statements and standing by those statements alone without ample evidence. So I appreciate you two's commentary. It helped me out.
Thank you. Other questions or comments?
Mr. Chairman, I would just add to Commissioner Williams' comment. Years ago, obviously it was a good thing to try to sell a byproduct, a waste product, if you will, off for a recyclable end use, and to keep more and more of it out of a ash pond, or out of having to deal with it later, and to utilize it in a positive way as best you could. But of course, as we know, things changed, and I'm like you, Commissioner Williams. I think contracts should be fully abided by, but in this instance, when you look at the bottom line to the ratepayer, I'll take a net of $50 million benefit to the ratepayer, I'll take the $830,000 recoverable litigation costs for a $50 million net benefit to the ratepayer, because this could have gone on and ended up costing the ratepayers a lot more had it not been resolved. That's all I have, Mr. Chairman.
Thank you. Any other questions or comments? Okay, we ready to vote? Okay, all in favor of the motion, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
Item number 7, docket number 2019-179G. We have a request to withdraw a complaint.
Mr. Chairman,
Commissioner Irvin.
I move that we grant the petitioner's request to withdraw her complaint due to the resolution of the matter with Piedmont Natural Gas Company. So moved.
Thank you. You've heard Commissioner Irvin's motion. Are there questions, comments? If not, all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Turning to our transportation agenda, item numbers 1 through 3 are new applications that can be taken together. Item number 1, docket 2019-214, Steve Brinsfield, DBA Barefoot Airport Shuttle. Item 2, docket 2019-218T, Compassion Hearts Transportation LLC. And item 3, docket number 2019-228T, of Banks Resources LLC.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, I would move that we approve the applications and items 1 through 3 as read into the record by Mr. Menges. So moved, Mr. Chair.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Item number 4, docket number 2007-84T. We have a request to amend.
Mr. Chairman,
Commissioner Whitfield.
move that we grant request of DJ's Transportation LLC, care of Jackie P. White and Delbert T. White, to amend Class C taxi certificate number 7788 to read DJ's Transportation LLC.
Thank you. You've heard Commissioner Whitfield's motion. Questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Item number 5, docket number 2016-50T. We have a request to cancel.
Mr. Chairman.
Commissioner Williams.
Mr. Chairman, I move that we grant the request of Nathaniel Frazier to cancel Class C taxi certificate number 9154. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Williams' motion. Questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Mr. Chairman, that concludes today's agenda.
Thank you. If there's anything, is there anything else to come before us? If not, we are adjourned until next week.
Thank you for joining us. The Commission hosts business meetings each Wednesday to discuss dockets and issue directives, and each week we provide these post-meeting summaries to give context to the issues discussed. These meetings are usually held at 2 p.m., and all agendas and materials are posted to the docket management system in the days prior to each meeting. If you have questions about Commission business, we encourage you to reach out to us at robert.bachman, B-O-C-K-M-A-N, at psc.sc.gov, or via social media by following the SC Utility Consumer Program on Twitter at Utility Consumer and on Facebook at SC Utility Consumer. Today's business meeting started at 2:01 p.m. and began with the supplemental utilities agenda. This agenda was comprised of 8 separate petitions to intervene in dockets opened by the Commission related to the Energy Freedom Act, formerly known as House Bill 3659. That bill was enacted in May of 2019. Following motions made by Commissioner Belser, these 8 requests were granted. Next, commissioners discussed the regular utilities agenda, beginning with a request made by a utility company for an extension of time to file its annual report. Commissioner Hamilton made the motion to grant this request, and that motion passed. Item 2 dealt with Blue Granite Water Company's petition for rehearing and reconsideration of Commission Order Number 2018-802. For context, on May 29, 2019, the South Carolina Supreme Court remitted this matter back to the Commission. Following this decision, ORS filed a memorandum in opposition to Blue Granite's petition for rehearing or reconsideration, stating, "The Commission ruled properly in its order on reconsideration that customers should not be responsible for the company's decisions that failed to minimize costs and failed to operate in good faith in order to comply with all applicable laws and regulations." On June 14, 2019, Blue Granite filed a reply to ORS's memorandum of opposition, stating that ORS's assertions are not supported by the record of this case and that the memorandum, quote, mischaracterizes the benefits to ratepayers obtained by the settlement the company entered in the Riverkeeper litigation, end quote. With that background in mind, Commissioner Howard made a motion to schedule a rehearing and to set a date by which all parties should pre-file briefs. This motion carried. Commissioner Belser noted that she is recused from this docket. Item number 3 was a request made by Duke Energy Carolinas LLC to dismiss, along with a request for confidential treatment of Exhibits A and B in docket number 2019-164-E. Commissioner Belser noted that verified testimony indicates that power had been restored in this case and moved to dismiss this complaint. This motion carried. Item 4 dealt with a request by Duke Energy Progress LLC for their annual review of base rates for fuel costs. Background follows now. South Carolina Code Annotated 58-27-865 establishes a procedure for annual hearings to allow the Commission and all interested parties to review the fuel purchasing practices and policies of Duke Energy Progress LLC, and for the Commission to determine if any adjustments in the fuel cost recovery mechanism are both necessary and reasonable. On June 6, 2019, the Commission held a hearing to determine precisely that. Prior to this hearing, the ORS filed a stipulation made between ORS, DEP, and Nucor Steel, resulting in a net $1.95 decrease to the fuel cost rates to consumers. Commissioner Williams then moved to adopt the joint proposed order today, as it results in a decrease in as it results in a reduction for the typical residential customer, and to adopt the values stipulated between the parties. Commissioner Whitfield noted that he was not present at the hearing and will not be voting today. Commissioner Williams' motion carried. Next, the Commission considered the Office of Regulatory Staff's petition for clarification and reconsideration and Duke Energy Carolina LLC's petition for rehearing on Commission Order Number 2019-323 and South Carolina Energy Users Committee's petition for rehearing. This case involves 3 separate petitions for reconsideration and/or rehearing of Commission Order 2019-323. Taking these requests one by one. The SC Energy Users Committee's petition pertains to the treatment of pre-construction costs, coal ash recovery costs, and real-time pricing. Duke Energy Carolina's petition challenged the Commission's disallowance of coal ash remediation and disposal costs, the treatment of certain deferrals, the return on equity, and the treatment of coal ash litigation expenses. ORS's petition asked for clarification of certain issues, including working capital adjustment, executive compensation, deferrals, rate base and net income for return, and the cost of service study methodology. Commissioner Irvin noted that 3 parties have contested certain portions of Commission Order Number 2019-323 and proposed a motion with a full written order to follow to uphold the original order and adopt additional provisions that preclude further rehearing or reconsideration related to these dockets. The complete text of this motion will be available for public review on the docket management system. Commissioner Williams then noted that while his opinion is that the notice given did not violate due process, it is not, quote, good sound public policy, end quote, to allow increases beyond what is noticed, quoting from ORS's petition for rehearing, quote, utilities cannot make dramatic changes, quote, higher than the noted rate. He then suggested that all future communication between utilities and ratepayers be drafted in plain and clear language, digestible by the public. Commissioner Belser then clarified that adjustment number 33 was covered under the Commission's ruling, not adjustment number 333, as there was some confusion. Commissioner Irving's motion then carried. Again, the full text of that motion will be available on the website and through the docket management system. We'll also point that out on social media, so do follow along for that. Item 6 covered Duke Energy Progress, LLC's petition for rehearing or reconsideration of Commission Order Number 2019-341. ORS's petition for reconsideration and clarification, and SC Energy Users Committee's petition for rehearing or reconsideration. These three entities are seeking similar clarification to those sought in Item 5 above, with some changes. SC Energy Users Committee's petition pertains to coal ash recovery costs and real-time pricing, DEPs to the disallowance of coal ash remediation and disposal costs, the treatment of certain deferrals, return on equity, and the treatment of coal ash and certainteed litigation expenses, and ORS's for clarification on rate base and net income for return, cost of service study and methodology, executive compensation, certain non-allowable expenses, and deferrals. This afternoon, Commissioner Whitfield raised a motion noting that the Commission will shortly issue a full order that finds the Commission's final opinion is supported by the record. The complete text of the motion will be published shortly on the docket management system, and links will be posted to Public Service Commission's social media profiles. You can find those profiles at PSC of SC on Twitter, and also Utility Consumer on Twitter, and on Facebook at Public Service Commission of South Carolina and at SC Utility Consumer. Commissioner Williams spoke to the due process argument with similar comments as his comments from the preceding item, also noting that he has concerns about the company entering into contracts with certainty to sell gypsum, a coal ash byproduct, without taking into account potential regulatory changes. Commissioner Whitfield noted that there would be a net benefit to ratepayers and that a cost would be potentially recoverable under reconsideration. Commissioner Belser noted her agreement with this portion of Commissioner Whitfield's motion and asked that companies provide more information on certain issues. Quote, give us the information to really make your case, quote, in future cases. Commissioner Whitfield's motion then carried. I encourage anyone interested to please visit the SCETV page to view the complete meeting from this afternoon, including all commissioner discussion, and also do reach out to us if you have any questions about items discussed this afternoon. Finally, on the utility agenda, Commissioners granted a request to withdraw a past complaint following Commissioner Irving's motion. In addition to the items discussed today, the Commissioners were also advised on 54 further utilities-related items. You can find the complete list of these items and the corresponding docket numbers on the utilities agenda, which is available at the PSC website at dms.psc.sc.gov. That's dms.psc.sc.gov. Moving on to the transportation agenda. The Commissioners heard 3 requests for new applications for certificates. These were granted following a motion made by Commissioner Hamilton. Next, Commissioners approved a request to amend the name listed on a certificate issued to a transportation company. Commissioner Whitfield introduced this motion, which carried. Finally, the Commission discussed a request to cancel. This request was granted after a motion brought by Commissioner Williams. In addition to the items discussed this meeting, the Commissioners were advised on 6 other transportation-related issues. You can find the complete list of these items on the Docket Management System website at dms.psc.sc.gov. The next Commission business meeting will be at 2 p.m. on June 26. The meeting will be live streamed on our website at www.psc.sc.gov. And we encourage you to reach out to us for more information. And if you have any questions, please follow us on social media. Twitter, again, is at PSC of SC or at Utility Consumer, or on Facebook at the Public Service Commission of South Carolina or SC Utility Consumer, or do call our offices at 803-896-5100. Again, the next meeting will be next Wednesday, 2 p.m., June 26th. Thank you.